Is Google too big?
Doing some research for today's debate, I noticed that the Spiked website includes an endorsement by the great political philosopher John Stuart Mill, notwithstanding his death in France in 1873. Now, Mill had a lot to say on the importance of competition as a means of avoiding the evils of monopoly, which include the tax it levies on consumers by its laziness and incapacity. That's a quote. Now, while the teams of eager programmers at Google may be about as far away as it is possible to get from this description, it is worth considering in this context the scope of competition law, which exists ultimately to prevent the emergence and persistence of monopolies. It is important to note at the outset that European competition law does not prohibit a company from becoming as large as it can. Although there are exceptions, such as in the context of merger control, European competition law does not generally consider whether a company is too big. Rather, the law prohibits companies that have accumulated significant market power from abusing their position of strength. Put simply, all dominant companies are placed under a special responsibility not to distort competition in their favour. Or, put another way, while a dominant company is free to compete with its rivals by fair means, or what is called competing on the merits, it may not engage in abusive practices that could entrench or exploit its market power, and that's an important point. The list of abuses is not closed, and includes things like predatory pricing, product bundling, as we've just heard, loyalty rebates, discrimination, and refusals to deal. Of course, the really tricky bit in practice is working out the difference between benign and abusive conduct. This is important as the costs to society of stopping the wrong type of conduct can be very significant. In technology markets, which tend to be characterized by rapid innovation and a tendency towards significant network effects, including market tipping, this can be particularly hard. In theory, the potential for Schumpeter's winds of creative destruction to wipe the slate clean from time to time, as the new great innovation transforms the competitive landscape, means that we should be less concerned about the potential for enduring monopoly on such markets. But can we rely on this? If not, when should the authorities step in? To digress for a moment, I remember having to buy a special program for my first computer, a Mac Classic, and that's ignoring the Oric one because I think that barely counted as a computer, to enable me to read DOS disks or to read Word files on WordPerfect. The fact that, on the whole, I can now access pretty much any website or open pretty much any document on my Mac is due in part to the spread of open standards. However, it also relies, at least to some extent, on widespread adoption of proprietary standards, such as those found in Microsoft's Word, Adobe's Acrobat, or indeed Intel's processors. So, on the one hand, we have huge benefits to users from increased standardization, and on the other, significant barriers to entry for rivals hoping to replace the current standard. To paraphrase the Commission's case against Microsoft, if everyone can access content using Media Player, and everyone provides content in this format as a result, what room remains for competition? I also remember the first time that I heard about Google, when a law firm librarian told me that its searches tended to be more reliable than those by more familiar rivals such as Alta Vista. Remember them. Now, Google can tell me how many times I'm mentioned on the web in 0.12 seconds and provide me with an aerial photo of my holiday destination, driving directions of how to get there, and a weather report, all for free. Most of the information on which these services are based is freely available on the web for others to gather if they wish. Most modern browsers allow a user to choose their default search engine. On the other hand, we now hear from complaints to the European Commission that Google is allegedly manipulating search results to place its rivals at a competitive disadvantage. If true, this could well lead to concerns that Google is no longer competing on the merits. The devil will be in the detail, however, and unpicking the detail of Google's search algorithm is not for the faint-hearted. At this time, perhaps only two things are certain: that Google will continue to be the target of complaints alleging abusive behaviour, and that proving such allegations to the requisite legal standard will be far from a straightforward